This is Paul Turner, the Immigration Barrister at Imperium Chambers. Please contact me if you have any problems with regards to immigration, and please subscribe to my channel and hit the notification button for up-to-date immigration news as it happens. Today I'm going to be talking about the latest Home Office coronavirus concessions and the restrictions that they're now placing on migrants in the United Kingdom and those that want to come to the United Kingdom. This video is in the latest of a series and reflects the guidance that was issued today, the 15th of February 2022, and replaces the earlier guidance. If you're uncertain about your immigration status, then do get in touch with me, whether it's to do with regularising your status or general advice. The government continues to tighten its rules and cut the concessions. It is vital that you make any application as soon as possible and do not miss out. As we move out of the pandemic, these concessions are likely to vanish. The government's default position is that you should either leave if you have no reason to or remain, or leave to remain, or apply for exception assurance and or make an application as soon as possible. I will come to the tricky subject of exception assurance later on, but for a change let's start with the remaining concessions. Starting off with students. If you've applied for a child student visa or student visa, including Tier 4 visas, and are waiting for a decision on your application, you can start your course or studies before your application has been decided, if you meet the requirements of the student visa route, that is. However, if your application is ultimately rejected, you will be expected to leave the United Kingdom. Now, turning to Tier 2 workers. Here there have been some quite major changes, and they're not positive ones. It used to be under the previous guidance that Tier 2 applicants could start working pending a decision on their application. This has now been cut back and only applies to those that have applied under the health and care worker visa and are waiting for a decision on their application. This is probably due to the pandemic. Again, if your application is eventually rejected as invalid or refused, your sponsor will stop sponsoring you and you must stop working for them. You should either leave the United Kingdom, say the government, or seek to regularise your immigration status if this happens. Now, turning to NHS workers. It used to be much more relaxed in respect of NHS workers and their dependents, who could usually apply for free for an extension for a year. The Home Office took away the free exemption sometime last year, but allowed people to apply for an extra year. But it appears that under the new guidance, that the extra year has vanished. But it does say, however, that if you are working for the NHS, you can work in another hospital. Your hours are unlimited and your sponsor doesn't need to notify the Home Office. So there is some positive news that's there. Sponsors, as I've mentioned, will not need to change the place of work and will not need to notify them under the sponsorship management system. This is a major retraction of the earlier concessions, which allowed pretty much all Tier 2 migrants to start their job. Now, what I intend to do now is turn to those who want to apply for leave to remain in the United Kingdom or leave to enter the United Kingdom. A huge number of people, as is obvious from anybody that lives or breathes and reads the news, have been affected by the coronavirus pandemic and its impact on the economy. And whereas before the concessions were quite broad for those who want to apply for leave to remain in the United Kingdom, they've been cut back quite dramatically. There are, however, some remaining positive points if you are applying to enter the United Kingdom or want to remain in the United Kingdom based upon your family or private life. For example, if you have been unable to travel back to the United Kingdom due to coronavirus travel restrictions and your leave expired between the 1st of March 2020 and the 19th of July 2021, a short break of up to 6 months in continuous residence will be overlooked and you will face no adverse immigration consequences as a result, which is a positive move in respect of any future ILR application. However, the Home Office say that you are expected to make your next application as soon as possible when you return to the United Kingdom. Those who have already returned to the United Kingdom and did not make a valid application upon re-entry are expected, however, to make arrangements to leave. If you're here as a fiancé or proposed civil partner, the current immigration rules allow you to apply for an extension of leave for another 6 months if there are good reasons for why your wedding or civil partnership ceremony did not go ahead. COVID, or the coronavirus pandemic, will generally be considered a good reason, so that's a positive. The concession in respect of the minimum income and adequate maintenance requirements do continue. However, these two have been cut back, and cut back quite dramatically. The concession that remains that if you've experienced loss of income due to the coronavirus pandemic up to the 31st of October 2021, the Home Office will consider employment income for the period up to the time that you lost the income, provided of course that you meet the income requirements for the 6 months prior to the date you lost your income. If your salary was reduced because you were furloughed, the Home Office will take account of 100% of your salary even though you weren't paid 100%. If you're self-employed, a loss of annual income due to coronavirus between March 2020 and 31st of October 2021 will usually be disregarded, along with the impact on employment income for the same period for future applications. So there's a benefit there. The big change here is that the concessions have not been extended beyond the 31st of October 2021. Any income loss after that date will not be taken into account within the financial concessions that I've already talked about, and applicants will be expected to meet the usual financial requirements, i.e. 18,600 over the last year, or 9,300 in the last 6 months. The concession in respect to specified documents continues, so if you can't provide all the specified documents, the governments will still entertain applications. And as anyone knows, with regards to the immigration rules, specified documents can sometimes be of great importance. Finally, if you're asked to take an English language test as part of your application, you can apply for an exemption if the test centre was closed or you couldn't travel to it because due to the coronavirus when you applied. Overstayers. There is still a concession if you have overstayed your leave. This concession applies to the people that overstayed between January 2020 and 31st of August 2020. The government say there will be no adverse future immigration consequences if you didn't make an application to regularise your status during this period. But you must seek to regularise your status now. Again, this is welcome because if you come to apply for ILR, this gap can be overlooked. Now I'm going to look at returning residents. Indefinite leave to remain. Now, some indefinite leave to remain usually expires or lapses if you've been out of the country for more than 24 months, though you can apply to get entry as a returning resident if you've had good reasons for staying outside the United Kingdom and it's going to be your home. Thankfully, the government has seen sense and extended this to those that have been stuck outside the United Kingdom for more than 24 months due to the pandemic. This will generally be considered a good reason, though you will need to apply on the returning residents form. Now, moving away from the concessions which I've touched upon to the hardening of the government's position. And you must be warned that if you fall foul of any of these rules, you will be treated as an overstayer, subject to the hostile environment, arrest, detention and potential removal. So they're very important. The government's standoff position is that they expect migrants to take all reasonable steps to leave the United Kingdom where it is possible to do so or regularise your stay in the United Kingdom. If you intend to leave the United Kingdom to a country or territory but have not been able to do so and you don't have a visa or leave or exception assurance that expires before 31st of March 2022, you may request additional time to stay, known as exception assurance. I've touched upon this before. This is for individuals whose country of residence is red listed, or there are exceptional cases where you are unable to return to a country or territory where that nation has closed their borders or where quarantine facilities are temporarily oversubscribed. This is an application that needs to be made by email and supported by evidence. You can't just say, I can't go home, I couldn't go home. If you've previously been granted exception assurance, which is not leave per se, but means that you're essentially in the country lawfully, no adverse inference will be drawn from having exception assurance, but you will need to make a fresh application. Of course, the alternative to applying for exception assurance, which is essentially a temporary provision, is to make an application for leave to remain in the United Kingdom. This too has been tightened up to include only those who are allowed to switch their visa and represents a cutting down of the previous relaxation to leave the UK to reapply to enter the UK. So in short, as we leave the pandemic, hopefully leave the pandemic, the Home Office concessions have been significantly cut down. For example, in respect of Tier 2 workers, it now only applies to healthcare workers. And in respect of the NHS, they no longer get a 3 years extension. In fact, there's no mention to any extension to the visa, even if you're working for the NHS. This seems quite harsh, given that people will have risked their lives and worked on the front line for a considerable period of time, some 2 years now, but there it is. The government expects you to act, and I can help you to resolve your immigration problem if you have one, or to make the relevant application as is required. I hope you've enjoyed this update on the new coronavirus guidance, which, as I say, has come out today. As I say, if you have any questions whatsoever, do get in touch with me. Please do not do something without proper advice, whether it's from me or another reputable lawyer. Making an application in these current uncertain times, or indeed in any time, is a highly risky business, given the Home Office's likelihood to say no if there is even the smallest mistake in any application. Thank you for watching this video. I hope it's been of some interest. I will continue to update on the latest changes as they continue to happen, and update on any immigration news. Please stay safe, the pandemic isn't over, and thank you again for watching. Please do subscribe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.